Buddy, can you guys hear me okay? Hopefully I'm coming in loud and clear. Hope you guys all had a good week. No, I did. I'm also speaking for my team members as well. Thank you guys for joining me this Saturday. Today is November the 19th, 2022. So they say. All right, so let's get directly into it. I'm going to take some questions. Go ahead and raise your hands. One question per person. If we go through all the questions, we will come back if we have time. We're going until 2 p.m. today. And if we have enough time, we'll answer additional questions if you may have them. I will stop in the middle of answering questions and read a little bit of material from the IRS, some of the publications that they put out. I think it's very important for us to know what they're putting out and what they're talking about when it comes to trust, partnerships, corporations, 501c3s, implied trust, express trust, pretty much everything that we discuss inside of the Patreon courses. So my assistant is here, Isaiah as well, our liaison. Both of them will be monitoring the chat. So if I don't get a chance to see your question or your hand, maybe something's going on with your microphone, you can ask your question in the chat and they will go ahead, let me know, and I will answer it as quickly as possible. So first person to have their hands up, we have Lisa Pizzela. You may unmute your mic. How are you?
Hi, I'm good, thank you.
Good.
So I have several, but I'm gonna just ask you this one. It says in the guide, steps 1 through 4, page 10, it says you can't have a trust unless there is real estate attached to it. I don't have any real estate. What does that mean? I mean, I do have real estate, but well, it's already, they're already in a land trust, but anyway.
That's fine. That's fine. If you control that land trust, you may use that property. By any chance, can you let me know and let everybody know what state are you in?
Sure, I'm in Florida, and the properties are not in Florida. They're in Ohio and Indiana, but no, I'm not running the land trust. Another company is.
Okay, all right. In the beginning, when I did this process, of course, the laws say that you do not need to have real property to begin your trust, right? You can have your own trust property regardless of what that is. However, when it comes to recording express trust and they understand full well what we're doing, they're trying to throw loopholes at you. And so from state to state, you may find it a little bit easier to get it recorded without real property. In some states, you may find it difficult where you need it. You may want to try it without. And what I would suggest is utilize different commodities, such as the ownership or stock in corporations. If you have a corporation, it could be gold, it could be silver, it could be whatever you consider to be property. Try that first. If they come back and say, no, you need real property, there is another method that you can utilize. And that's the very same method that cities utilize when it comes to recording different contracts down at the county. For example, if a county decides to do renovations and they hire a construction company, well, they're going to make sure that that construction company obtains a bond that their work is going to be insured to be to where they complete their contract with the city in a timely manner. That contract can be recorded in the county along with a trust document. I'm actually going to be showing you guys, because of all of these changes that these local municipalities are doing, I'm going to be putting together a version 2 to the course that should be easier for you guys to get these things done if you happen to live in a state where they say you need real property, and that is not the case. So try to do it without real property. List any kind of commodity that you may have right now. If they come back and say it's not working, then I will have to go ahead and show you guys how to record your declarations of trust as a trust indenture or a memorandum of trust and you're going to attach an actual bond with it. They will not refute your documentation if you attach an actual valid bond. Okay.
Okay, I do have an S corp, but I don't really use it too much.
No, perfectly fine. You don't have to use it as long as it's active and standing. We can list that as what we call the principal in your bond. To go out and get anything, a bond anywhere from 10,000 up to 50,000, maybe 100,000, and they're not expensive to obtain. I will show you guys which is the best vendor to use, because most of us don't have real property. We're expiring to get some in the future, but most of us don't have it. So there is another way to get this done. So stay tuned. I will show how to do that.
Thank you.
You're welcome. All right, let's go to Frenchie.
Hi, Avery. Hi, everybody. How are you?
Doing good today. Thank you.
All right. So I have CJ with me. So it's going to be one question for me and then one question for him. Mine is going to be relatively short. So I'm in the process of opening my trust enterprise. They messed up yesterday. So no issue with the wording of grad, irrevocable, all that stuff. I've seen a lot of people having some sort of issues, and literally it's the first bank that I try and it went well. They just were telling me that the document that I was providing, which I follow your guideline that you have on the Patreon, was just the 3 pieces of information to provide. That was well enough. They just were saying that the format of the information of the trust was a little bit different. So they are asking me to redo something, but I have a question on opening the enterprise trust. Can we make the family estate the beneficiary of this trust? And if so, what are the benefits of doing if we want to do that?
And you are speaking of opening a bank account?
The trust, the enterprise trust.
Okay. Yes, you're going to use the enterprise trust to open a bank account, but it's usually not the bank's, it's not their business to know who the beneficiaries are. So this is why we give them that certificate of trust. It has very limited information. All they need to know is the settlor and the trustee. That's it.
Well, what they gave me today, I had to go back this morning because basically yesterday we were like 99% done, and she messed up. She put my social instead of the EIN of the trust, which I caught. So
well, she's supposed
I'm sorry?
She's supposed to put both down.
I understand, but what was the tax identification number, the 10, was under my social and not the trust EIN.
Okay.
So she messed that up. So I went back this morning, they fixed that, but she came back with this certificate of trust, which is like a Lambda 1 from Illinois, that they want me to give this back. They said that there is no issue. They're going to open the account. I actually have the bank account number, but they were asking me for that.
Yeah, sometimes they give you their own format of a certificate.
Yes, correct. So there is nothing wrong with that?
There's nothing wrong with it. All I want you to do is if there's a section on there that asks for a beneficiary, you know exactly who to put down. You want to put the Foreign Express Trust name.
That is correct. No, they don't ask that.
Okay. And you should be fine.
Okay. Okay. But can we put the family estate, the beneficiary of this trust?
There's no point.
Okay, no point.
No point in doing it because you are the trustee, and we already know that, that name is already under the 8832 filing that you've already done.
Yes.
Yeah.
Okay. All right. That was it for me. Thank you, CJ.
Hey, Avery, how you doing?
Good, CJ. Thank you.
All right. My question is, it's pertaining to the UCC, the non-UCC. I filed it. I got it filed in the county, and I think I remember, but I couldn't find it. Once we got that process done, are we supposed to go and do just a regular UCC now and just, or UCC 3, and then like to attach it to the one that we filed in the county? Are we supposed to go back and do one to put it like on the state level or something like that?
Forgive me, I'm
asking that.
gonna have
Huh?
to, you're gonna have to forgive me, you guys. I'm gonna have to mute out. We do have some construction going on around here. But I did get the gist of your question, basically the order of operations in regards to the UCC.
Yes.
So you're going to list your promissory note, your birth certificate information, even if you want to put all of the different formats of your DBA names inside of the collateral on that financing statement form. Now you will check off public finance transaction, and you will check off that it's held in trust, and you will check off non-UCC, right?
Yep.
Use that as a cover. Behind it will be the declaration of trust, the hold harmless indemnity agreement between you and your foreign trustee, if you have one. You want to have the promissory note, and you want to have your trustee minutes number 4. You guys get that in the junior class. That is your nationality declaration. That's all I want you to add when you record it down in the county. Sometimes they put that in the real estate record. Sometimes they put it in the miscellaneous file. Sometimes they may even separate. They may say, we only want your financing statement by itself, and then we're going to record everything else by itself as 2 different file numbers. That's perfectly fine too. Either way, once you get that done, you're going to take the file number that they've given you on those recordings. That's the file number, it's the date, it's the seal, it's the name of the clerk of court, it's the book and the page number. Take that specific information. You're going to do another financing statement. You will put it on the collateral section. And all I want you to do is attach your promissory note that was recorded in the county. This will be considered a UCC1, a notice of lien. That means on this financing statement, you're going to uncheck the box non-UCC, and that is recorded online with the Secretary of State.
Okay, so I just uploaded my documents and I got a file number for the UCC. And so I didn't take my promissory note and my whole harmless agreement and have them actually file those documents. I just attached them in a UCC where you can upload documents. So I already went it with when I took my UCC in there, I already had a file number in there. So I didn't give them those exact documents. Did I do that incorrectly, or how should I do it moving forward with just the original, like going back to just the UCC, the regular UCC, not the non-UCC?
Well, you want to get those documents on file because that is what you call registering the trust within probate. Okay.
Okay.
So you can do a UCC3 to do an amendment for that.
Okay. And then I should take those actual documents and have them file those documents with it.
Exactly.
All right. Okay. So me uploading them when I was doing the non-UCC is not going to hold the same type of weight.
Yeah. If you just do the non-UCC by itself, you got to have the meat and potatoes to go with it.
Okay, so me uploading the documents is what then?
It's
what
fine to upload and that they accept electronically.
Yeah.
But you want to upload all of those pieces of information that I mentioned.
Yes.
Whether you
I
walk
did.
in or whether you electronically file it. So
yeah. So
now,
I did do it that way. I did upload those documents that you're referring to, the whole harmless, the promissory note.
now when you go to the website, when you go to the county website, are you able to search the file numbers and find it?
That's what we were trying to do.
Yeah, I was trying to find, that's what I was trying to do the other day. I was having a hard time trying to locate where I can find that information. So I haven't found it in the county yet, but the UCC, I found that file number. I looked that up. I was able to find that, and it had listed all the DBAs that we had to do as debtors and stuff like that. So that's all on the UCC, non-UCC. But it seems like I might need to go back and actually
amend,
do an amendment and then attach those files and then come back and do the UCC referring back to that file number.
Well, before we move forward, I know you guys are going to go ahead and get another 2-hour session with me. So let's take a
Yes.
look, try to find that in the county before we move forward.
Okay.
Okay.
All
Okay.
right.
Thank you.
All right. Thanks.
You're welcome. All right. Hey, Isaiah, you got any questions for me? Go ahead and unmute yourself.
Hey, how's it going, Avery? Yeah, we got a few questions in the chat.
Right.
So this one's from Tristan. Should I record trust in every county I have property in within the same state?
That's going to be very well. If you successfully do that, you're going to be the master at recording trust. And there's nothing against doing that. I would say get DBAs in every state that you can, or county, and also get injunctions. I know how much that's going to cost, but in the long run, it is how we bring back the republic. If everybody does their share in doing that, that will be great. But when it comes to your trust, it only needs to be done where you're locally doing commerce on a 24/7 basis. You can take your trust and record it into one of the 17 discretionary trust states, such as Wyoming, Delaware, South Dakota, and there's others. That's perfectly fine to do that. That's what I would recommend. Do that first. So do it where you live and then take it into one of those 17 trust states. But it does not have to be in every state unless you are a super real estate titan investor, then it makes sense to do that. All right. Any other questions in the chat?
Yeah, we got 2 more questions for now. Basira asked, how do I change the name of my Express Trust Enterprise? I have already my bank account open.
I'm assuming that you already have the EIN associated with the trust enterprise name that you no longer want. That means you're going to have to take the name that you no longer want, go and file a DBA, and you choose the name that you want that to be. So let's say it's One Trust Enterprise. You don't want it to be One Trust Enterprise anymore. So you would have to file a DBA saying One Trust Enterprise is doing business as Two Trust Enterprise. You take that recorded document down to the bank and they will update the name on the bank records. All right, next question.
And it's from Amparo. It says, Avery, can I put my real property in the trust, but continue to pay taxes until I'm sure I'm not going to sell? Or can I pay the county, but get reimbursed by the IRS?
Yes, you can. You definitely can do that. It's actually a good practice to do it that way, especially if you're not sure if you're going to sell it or not. You guys can put your properties in the express trust using a quitclaim deed, no problem. It's just if you know that you're going to sell the property and that was the overall intent of you and your family, then do not proceed with a real estate assessment appeal with the county. That leads into land patents and all things with that. We don't really care about land patents. That's under the Federal Register system. We don't want that. What you want to have is a lis pendens, a forever lis pendens on your property if you do decide to not sell, to keep it, and you want to take it off of the county tax rolls. So if you plan on selling it, you can put it in the trust. Don't worry about doing assessment appeals because you're going to sell the property anyway. So I think that was it in the chat. Thank you, man. I'm gonna go ahead.
I'll let the questions build up and then raise my hand again.
All right, cool. All right, let's go to Blue Nova. You are unmuted.
How you doing, Avery? Can you hear me?
Yes, I can. Thank you. Doing good. Thanks.
Hello, can you hear me?
Yes, I can. You're good.
Okay, my question is, we doing the injunction. It's for the parties that we send it to. I remember watching the Charlie Weiss video and he had sent it to the parties' wives. We're not doing that correct. We're only sending it to the ones on the paper that you presented to us.
Yeah, you mean Charlie Sprinkle.
Yeah, Charlie Sprinkle. Sorry about that.
No problem. Yeah, back in 1973, he decided to sue Ronald Reagan for being pulled over. They tried to give him a license or a ticket because he didn't carry a license. And he firmly made that, um, he told the court that, look, the state of California is not supposed to issue any titles of nobility. And that's what a driver's license is, especially if you're operating an automobile, a locomotive that's under 10,001 pounds. So he won. If you read the case, it's going to look like he didn't win, but they actually didn't require him to get a license. He continued to drive that way, continued to be pulled over, and they left him alone. So that's what we call the permanent injunction. We used that case law as a model for putting our writs of injunctions together. He had served in that case against Ronald Reagan and his wife and everybody that was attached to the government seat, including their children. That's what you call Rule 17, suing under personal capacity, right directly in their name. So yes, that is exactly what he did. It's under Rule 17. That only can happen if you're suing in equity court. If you're suing in a court of law, you can't do that. You have to sue in the government name or a corporation name. But if it's an equity court suit, you can sue directly in their personal capacity name. So if you have your injunction filed and you're looking to do the very same thing, you want to make sure that your trust is going along with that. You don't want to do this in just your regular name. But very good comment. Did you have anything to add to the state injunction? Mr. Blue, did we lose you? All right, we're going to go ahead and move on.
No, sir, that was it. Thank
Are
you
you good?
very much. I appreciate you. God bless you.
Thank you very much. Thank you. All right, let's go to Susan. All you got to do is unmute your mic.
Hello, Avery. Thank you so much. We appreciate your time today.
Thank you.
We're newbies, so I'm sorry. I'm going to ask a question that maybe has already been answered on another Zoom. But as a husband and wife, we're wondering if we need to each have our own 98 number, or do we have like a top 98 number that we would tuck ours up under? We're just not sure how we need to proceed.
Okay, good question. Yeah, we've answered it, but we don't get this one too often. So it's good to do a refresher. You definitely want to have your own trust for each of your estates. Okay. You had your own estate before you met your husband, and he had his own before he met his wife. So wife is going to have her trust. She's going to have her estate. This is what you call the life estate. Husband is going to have his trust, and he will have his estate incorporated into the jurisdiction of that foreign trust. Why? Just in case something were to happen to one of you, you're not leaning on the other person's trust to get by. Now, what you want to do is create a third trust. This is the marriage covenant trust. This one will be created. You guys can select whichever trustee you want to be a part of it. I suggest you still use a foreign trustee and have that foreign trustee hire a public trustee, and that can be a company, to operate in the public's behalf for it. But you're going to have husband's trust and wife's trust act as the beneficiaries within this marital covenant third trust. You can obtain life insurance policies with that trust, and this is going to fund your family, your children, your pet, real estate, medical, dental, everything can be based off of this life insurance policy, depending on how large you want it to be. Most families, the wealthy families, they like to utilize the life insurance policies that's connected to their family marital trust as what's called a collateral assignment. Sometimes when you apply for a loan, if your credit is not good enough, they would utilize the collateral and the death benefit of the life insurance policy to actually get the loan that they're looking for. The collateral is basically this: if you don't pay that loan, they know that they're going to get the money back when the two estates pass away. or the insurer. So there are ways to be creative. But to go back to your question, yes, you want to have your own trust with your estate comprised in that, and your husband will have his trust with his estate comprised in his trust. Okay. That answers your question. Going to go ahead and move on to the next person with their hand up. I'm going to go to Serge. All you got to do is unmute your mic. Good to go.
I can't hear me loud and clear.
Yes, I can. Thank you.
Hey, Avery, thank you so much for taking my question here. And my question is concerning about the process for a naturalized person, because I've recently just got into your course. It's been less than a week now, and I got the complete course from freshman to senior, and I went through all of it, and I see how I explain how the process worked for a naturalized person, for somebody that was born outside the United States and then got naturalized to be a U.S. citizen. Because in my case, I want to know how does this benefit me, because I was born in Haiti, I naturalized while I was in the Marine Corps, and I got the Marine Corps. I'm currently receiving Marine Corps disability compensation benefits as well as Social Security disability benefits. So if I create Express Trust, do I lose those benefits, or can my Express Trust claim these as assets and under that? But can that process also work for a naturalized person? Because I don't know if you covered that in the previous Zoom call, but I like to know, how does it work for a naturalized person who's also a military veteran getting disability compensation and Social Security compensation, which are both tax free? Does that make sense?
It makes perfect sense. I don't remember the exact US code, but it's under Title 18. They cannot take away from you any of the benefits and privileges or even pensions that you've accumulated, whether you served in the military or not. They cannot take that away from you simply for doing a process such as this. If you've earned money within Social Security, a pension plan, military, if you're a veteran, you are owed those monies, whether you do a process as this or you don't. Okay, if you are born in Haiti, all you do is this. You have a certificate of naturalization already. That is already authenticated by the Department of State. All you have to do is go down to your consulate, the nearby Haiti or Haitian consulate in the state where you're living, and they have a process for you to begin authenticating your birth. That's located in Haiti. If it's in another language, they're going to translate it automatically into the English, and then the consulate will authenticate it for you there. So now you're going to have two different documents, one that's authenticated by the consulate, and you're going to have your natural certificate of naturalization. Those two numbers are going to be placed in the collateral box in section 4 on your non-UCC. Now, yours is going to be a little bit different than someone who's born here in the United States. Once you've authenticated your birth certificate, you now have to take that information, according to Minnesota Rule 220, you have to list it with the registrar of titles. That's the recorder clerk. This is why I want you to have the adult, we call it the affidavit of domicile, the claim of ownership. Yours is going to state the very information that I gave you guys in the template. However, I just need you to add your certificate of naturalization number, and I need you to add your Haiti consulate number to that affidavit. When you fill out that affidavit, it's going to be notarized in your state. You're going to send it to be recorded with a local newspaper. That newspaper company will give it back to you certified, and then you go and record it down at the county as an affidavit. They're not going to reject it. They're going to record your actual certificate of title information with your trust, so to speak. Okay, that's the process. Anyone who's born outside of the country, you must go to your consulate and add it with your certificate of naturalization. Hope that answers your question.
Yes, I did. Thank you. Thanks. Oh, thanks so much. And and I can call you for consultation, basically. I could do that, correct?
Yes, you can. Call the
Uh,
number 888-899-2262. I'll put it in the chat for you guys, and you can set up a consultation there.
all right, thank you so much. That's it.
You're welcome. No problem. Right. Is there any more questions in there? Should be good, right? I don't think there's any more questions. All right, let's go to Makisha. You are unmuted.
Hey, Avery, hope all is well. My question is previously, it's been a while, but you said you were working with training a few CPAs that could kind of work with us. So has that been accomplished?
I'm so sorry. I was reading a comment. One more time. One more time.
CPAs, you said you were training up someone
Right.
so they could work with us. Has that been accomplished yet?
Oh, no, not accomplished.
Is
Well,
that not-
possibly, maybe. We're still working on that. But
Oh,
we're gonna, it seems like what's gonna be for sure is to get to the point where we have enough people who have done this process completely,
uh-huh.
and they are ready to file their taxes. They will join me on a separate webinar, qualified webinar. This means that I'm going to look at everything that you've done, and I will say, okay, good, you're qualified to come into this webinar and learn how to actually fill out the 1041. So
Okay.
that's going to be that, and then you can take that, in correlation. If you may know any CPAs that can look at it, you can train them yourself. But I would much rather you guys get the experience in doing what they're going to do for you, and
Okay.
that knowledge is priceless. So
Okay. And for someone that's getting, I told you I'm getting a large grant. I have several people that are getting this particular grant. If they're not set up with their trust now, but they want a trust, as long as they set their date to either majority or no, or I think you said no longer than 3 years, can they still take advantage of that zero tax liability?
yes, they can. And that's the whole point of your promissory note being put together and recorded down in the county.
Okay. Okay. All right. Thank you. Appreciate it.
You're welcome. All right, you guys, let me take a break from questions. I'm going to read some material here. I'm going to go to my screen. We are going to read an IRS publication, and this has actually been analyzed by Ward L. Thomas and Leonard J. Henske Jr., talking about the common law, Internal Revenue Code 501c3, which we don't want, right? However, you can utilize it if you think about doing something like a charity or something of philanthropic endeavors. Okay. I'm going to read a couple of sections in this book. Kind of like a review. Here we go. What is a trust? Trusts are one of the major forms of organization for federal tax purposes, along with corporations, partnerships, and governmental units, right? Restatement definition. The restatement second of trust, hereinafter, restatement is, it defines a trust generally as a fiduciary relationship with respect to property, subjecting the person by whom the title to the property is held to equitable duties to deal with the property for the benefit of another, which arises as a result of a manifestation of an intention to create it. Okay, let's go down. Look at the parties of a trust. Trusts are defined in terms of parties: grantor, trustee, beneficiary, and relationships pertaining to the trust property. Remember, this is a publication coming from the Internal Revenue Service back in 2003. Grantor. Every express trust has one or more grantors who contribute the property to the trustee. and state the terms of the trust. So in your templates, you guys know that the very last paragraph before you guys sign, it's talking about the terms of the trust. The grantor is deemed a substantial contributor, disqualified person with respect to the trust. A grantor, there's another way of calling them: creator, donor, founder, settler, trustor. Depending on your state, they call it a different thing. If you've used settler and your state says it's a donor, will you be penalized for that? No, you won't. It all means the same thing. Trustee. The trustee or trustees receive the property and hold it for the benefit of one or more beneficiaries. The trustee is the legal owner of the property, but must use it for the benefit of the beneficiaries. So they can't just use the property for their own self-good. It has to be for the benefit of the beneficiaries. As a fiduciary, he owes the beneficiaries duties of loyalty and care. You guys know I'm a big movie buff guy, so in the John Wick series, there was nothing but trust indentures and contracts everywhere. Different trustees and fiduciaries carrying out different types of obligations, and they like to use a certain word. In the last movie, they used the word fealty. How does the trustee pledge their fealty to the trust indenture? It's exactly what your trustee is doing. It says the grantor and trustee ordinarily may be the same person and may create the trust by declaring that he holds certain property in trust. It's a very important statement here when it comes to your trustee seeking to come to the States. If you want them to obtain a business visa instead of a visiting touring visa. Sometimes they don't approve that, but they will approve contracts recorded in the counties with the United States. The sole trustee and the sole beneficiary may not be identical because the purpose of a trust is to separate the legal and equitable interests. So your sole trustee is going to be a non-resident alien from another country, and the sole beneficiary is going to be who? The trust itself. The trust itself is a natural person. The foreigner does a work for the trust. The trust is holding property that the grantor gave to the trustee to operate for the trust. That's how this works, right? The beneficiary, also known as the Cestui Trust. Some people have heard of the Cestui V Act of 1666. 666. 6, 66. That's a biblical term. And we know that that translates to the titles of the papacy. That is every single person that has been entered in the role of the Pope. That's what that belongs to. First Caesar, or the one who took over after Caesar, Emperor Nero. So the Cestui Trust is the beneficial or equitable owner of the property. The beneficiary is said to have the use of the property and can appeal to the court for an accounting or replacement of the trustee to ensure proper use of the property. That's coming from Black's Law Dictionary, right? Let's go down a little bit more and we'll go back to questions. Can a trust exist without assets? By definition, a trust is a legal relationship with regard to property. Thus, the common law rule is that a trust does not exist without a residence, trust res, okay? Thus, the common law rule is that a trust does not exist without a res. This is property. You must have property for a trust to exist, and it has to be at least $1 in value. This is why you don't have to have real property for your trust to exist. You can utilize this American jurisprudence as proof to whoever is telling you you have to have a house in order for your trust to be recorded. And you can pull it up. Actually, I would bring the book that says this. It's a thick green book that would have that and says, look, as long as I have property in my trust that's a value of at least $1, I can record my trust here. It may be a fight. If you don't want to go through the fight, then find some real property and add it to it, right? It just depends on how far you want to go with it. Like I said, if you're having issues in your state and your county, come to where it is easy, such as Florida, Seminole County, Osceola County, Citrus County, Miami-Dade, Broward, Duval County. It's easier there. And then take that jurisdiction into your county by just filing a DBA, and you get it done. Alternatively, the owner may simply declare that he holds his property upon a charitable trust. No transfer of title is necessary. A promise to transfer property to the trustee does not create a trust unless the promise is enforceable as a contract, aka the promissory note. This is why I gave you the promissory note. It doesn't matter if the birth certificate is valued at $1 or more. There has to be a valid contract to go with the declaration of trust. There must be. A trust that lists no assets in its Form 1023 balance sheet should be required to cite the proper state law that it nonetheless exists as a valid trust under the state law. We're not using forms to get jurisdiction here. We are avoiding all of their forms. Everything we do is in-house and we make it ourselves according to common law, right? Can a trust exist without a trustee? Trustees may die, resign, become incompetent, or be removed as trustee by the court for cause. See American Jurisprudence 2D, Section 254. If a trust loses its trustee, the court will appoint others. A trust will not fail for lack of a trustee unless the settlor manifests a contrary intent, right? If a trust loses all of its trustees during the application process, the determination specialist should ordinarily wait until the new trustees are appointed before recognizing exemption to ensure that the trust will, in fact, continue. Now, of course, we're talking about a trust that is required to be recorded with the court. That's the inter vivos trust here, living trust, spendthrift, all of those things are under statutes and codes where they require these things, but your express trust is not. If you have a trust that has a domestic trustee, do you need to have that recorded in court? No, you don't. And I'm going to get to that. There's a section here. That was the last thing that I wanted to read. Here we go. Before we get back to the question. It says, the question is, does a trust have to be registered with the state? Many people have been asking this question. They don't understand if it should or shouldn't. If you register, are you giving jurisdiction? That's the main concern. Let's talk about it. No state filing. Unlike corporations, LLCs, or limited partnerships, trusts generally do not file their governing instrument with the state to become legal. Do we file our trust with the state? Do you find that information anywhere within Patreon? No, you don't. You file it at the county. Two different jurisdictions. County is the highest seat in government, above FBI, all that. However, a will that includes a testamentary trust is filed with the court as part of the will probate process. A few states have adopted Article 7 of the Uniform Probate Court Code, which requires the trustees of all trusts to register in the court of the principal place of administration of the trust. The Uniform Probate Code imposes penalties on the trustee for failure to register, but does not invalidate the trust. The trust instrument usually indicates the state law under which the trust is organized. That's exactly what we've done. Last paragraph of your declaration of trust. If it doesn't, the determination specialist should ascertain the state law and get a representation from the trust that it is properly organized under the state law. See, we put all of these parameters together in your trust so that you can avoid them placing representation on you. This is an attorney. If they can place an attorney on you, that means you do not have a foreign trust. If they can issue you your EIN number, you do not have a foreign trust. Stay away from it. Right. We've gone over a little bit of information there. We'll finish this up next Saturday. We'll start off here. But let's get back to the questions. All right. If you have any questions pertaining to what we just read, please do so. Just put your hand in or leave a note in the chat and I'll see it, because I actually want to talk about what we just read. Would be great. So let's go to, yes, I can post this document. I definitely will. I'm going to go to D verse. Your hand has been up for a while. You are unmuted.
How's it going?
Going good. Thank you.
All right. So I had a simple question. It had something to do about the trust enterprise. So when I did my EIN to get the trust enterprise, it came out as the name of my trust, and it just says trust enterprise. I know that in the videos that you posted before, it's supposed to say the name of your trust and express trust enterprise. Now, how
You
do
don't
I go?
have to.
It doesn't have to.
No.
So if I do an 88, if I did that, so I did an 8832 form to, reclassify my trust enterprise under my trust. I did the trust name Express Trust Enterprise. Does it matter?
It does not matter.
Okay.
It could be
Cool.
any if you want. And remember, you can always do a DBA to change it. You know, that can be its name to the IRS, but you can also have a completely unique name that's to the public and at the bank just by doing a DBA.
Understood.
I know people that have the name Latin Express Trust. Right now, they can say, I'm going to also create Latin Express Trust Enterprise for their trust enterprise. But you can do this. You can do Latin Express Trust is the 98 number. And you can say, I want Wayne Saxton, whatever trust enterprise. It could be completely different. It could be anything you want.
All right. Appreciate it.
You're welcome. By the way, Wayne Saxon is taken, so you can't use it, people. All right, so let's go to Lisa R. You are unmuted.
Hi, thank you so much. I'm a fairly new newbie, very green, and I had a question. I'm one of those people that got married, got divorced, kept my divorce name. I'm in the process of redoing my SS4 to get my EIN number because I used my real name in that, and I shouldn't have. I learned after.
Mhm.
And for a title of nobility, should I be using the country of origin for my birth,
Mhm.
or because everything's in my married name, which is my divorce name? So I always get hung up on which name to like concentrate on, I guess.
Gotcha. Good question. You can do a name change in the court if you want to. Most of us are preparing to do that. And we're going to change our name to our title of nobility name because we want to use that decree to get a final passport without using the social security number. So when it comes to title of nobility, all you have to do is search titles of nobility under Wikipedia and kind of see which of those names pertains to your nationality and your family heritage. That's usually the best way to figure out that name. Now, when it comes to the married name, Everything is done. I mean, you've done everything with that married name, which is perfectly fine. Just have to ask yourself, do you eventually want to change it back to your maiden name, or do you want to keep it? That's just a question that you would have to ask personally, right? So no big deal. No big deal. Now, if you've done, you got the 98 number with your current SSN name, you definitely want to just do the process again. This time select or give them a title of nobility name as the trustee, because that is a name that is not associated with the United States at all. Only use that name if you don't have access to a real non-resident alien who can be your foreign trustee. Okay, hope that answers your question. Yes, I need to make that clear when it comes to consultations. I only handle consultations that are pertaining to court matters. If you have an existing court case, that will be routed to me. If you are considered a private client, that will be routed to me. Any other situation is going to be routed to several of our consultants. Okay. Now I will brief them before you have your meeting with them. So that way we're talking about the same thing and everything is in unison. So just to be clear, when you guys leave your message, please state if it is a court matter pertaining to an active case number, okay, or you're trying to prevent a court case. Other than that, whatever it is, it's going to be routed to one of our consultants. But you must call that 888 number, 899-2262 to set that up. Sometimes it may take our system to go a little bit longer than 72 hours, but we see it and we will get to you. So please be patient. There's a lot of you out there. Lisa, I hope that answers your question. If you don't have any additional questions on top of that pertaining to your SS4, I will move on. Thank you for that question. Going to go to Rick. All you got to do is unmute your mic. How are you doing, Rick?
Doing fine, man. How about you?
Doing great. Thank you. Thank you very much.
Okay. First of all, can I get the program that you use to record our conversation?
Oh, yes. The last conversation we had, I believe I did send that to you. It didn't reach you at all?
Yes.
Did it?
But what I'm saying is, I want the system that records that, because
Oh, it was just the standard app that comes with my iPhone. That's all I use.
Okay.
Yeah.
Well, and I got a job.
Okay.
So I'm not going to do the Social Security thing.
Okay. So this is a job where they allow you to fill out a W-9 as an individual contractor, right?
No, it's not. I'll fill out a W.
If it's a W-4, then you have to give the social. You have to. Now, if you fill it out with the social, yes, you can fill out line 4C and put exempt and put 0 everywhere else. No problem. You're just going to have to give them your trust account, bank routing number, and checking information. Just give them a blank check to your trust enterprise, and they'll deposit all your monies to that account.
Okay. Okay. And dadgummit. Well, I wanted to do those two things. So I appreciate it.
Let's get together, fill out that W-4 together, and we'll send that off with a blank check that's linked to your trust enterprise. If they didn't give you any checks, just go down there and ask for one. They'll give you a blank.
Okay.
And they'll
Okay.
And all you got to do is give that to the employer and they'll set you up for a direct deposit like that.
Okay,
All
all
right.
righty. All right, I'll call you.
Yeah, give me a call on that number that I gave you.
Okay, all righty. Thank you.
You're welcome. No problem. AJ, you are unmuted. How you doing?
I'm well. Am I coming through okay?
Loud and clear.
Perfect. All right. Well, as you know, in our session together, that the situation with my sister and how the property, because my mom wanted to include her on title, they went behind my back to somebody and they filled out a quit claim deed. And somehow it got miscommunicated that not only did she get added, but my mom and myself were removed from the title. And so now I'm in the process of trying to reason with my sister. And you would think that the simple explanation of what happened, which she was shocked to hear, would have been enough to her just to turn around and say, okay, well, what do I sign? But I explained to her what needed to be signed, and the day came, she didn't want to sign it because she's reading this stuff and was confused as to the wording in there and was even questioning that part that says the money in specie. She says, why do I have to receive a money order? So I'm trying to figure a way of getting through to her with this information. She says she's going to go try to find somebody. It's been more than a week. She hasn't found anybody. So I'm thinking maybe I'll just send her some more information. But I needed probably an explanation too about that money order. She's a very suspicious person. So her brain is just all cylinders are firing, warning signs are firing because of she don't understand the wording. So what can we do?
So why would she be opposed to receiving a money order? Mostly when people close escrow, they receive a cashier's check. It's the same thing.
She's never done anything like that. She don't own any property. So she's never had that experience. So all this is brand new. So again, an extremely suspicious person who doesn't want to speak to me or my mom, and it's been some time. And so now, to my shock, again, this person agreed that she wanted to be removed off title.
Right.
And I explained to her, this is what the paperwork is for. You and mom signed paperwork that removed me without my consent, which was not legal either. But regardless, you didn't ask for an explanation of anything. You just signed stuff, and no money was that process wasn't even done. A similar process in that situation. So maybe that's why her brain is firing.
Maybe.
So go ahead.
Maybe that could be it. Could be it. So she's going off to go and find some help to get some understanding of the document that you gave her, right?
Who knows? I don't know.
Yeah, most likely they'll probably try to find an attorney to go ahead and do that. All she got to do is go to Google and look up monies and species, and that's silver dollars, that's gold coin, that's it comes in many forms. The only reason why we say that is because in like manner, how the property was taken from you to her, where nothing was exchanged, you're doing the same thing. If we list gold and silver coins as the money in species, well, you actually got to go get it and go give it to her. If you don't have it the day that she signs, then you can give her a money order, right? A money order in the amount of whatever you put on the document, just as long as you put that restrictive endorsement language that we've all learned about in 12 USC 411, right? To make it equivalent.
Okay.
So that's perfectly fine. She has to receive some valuable consideration. There has to be an exchange for equitable property. And that's really all you need to tell her. The trust is receiving the property. It's leaving your name. You have no more responsibility with it. You can move on. But in order for us to lawfully do this exchange, we have to give you something in return. It's called valuable consideration, right? It's If you go buy a house, they want a down payment.
Yeah,
That's
I
a
agree.
small valuable consideration.
Now, look, Lisa wrote in the comment, which is what I thought too. I thought that would be illegal. And she said it's fraud. She works for a title company. So what was done to me behind my back was fraud. So why doesn't it just cancel out what was done
Until
you
sue.
Until I sue?
Mm-hmm.
And so what would happen about in a sue process then?
If you sue, it would just completely remove her off the title. But that's going to be a process, right?
Mm-hmm.
And obviously you're going to want to sue with your trust as the plaintiff or the complainant, which you can do. You know, you and I work, so you can do that. But do you want to go down that route? You know, that's the question. Do you have time for it? You have to.
Well, am I not stuck right now? I mean, I sent off the 88 to 23, is it? I don't remember the number of that paperwork to the IRS, or the county. I forget which one that was. And so that hasn't come back. And I thought that the next step was at the same time to go file the trust. And so this is part of the thing. I need the property to do that.
Well, like we just read in this pamphlet here, your trust is already created, okay, as implied. And that's how the court is going to look at it. If they decide to look into the county, try to find it, and if they don't find it, it's considered implied, which can still hold your property. But we're talking about fraud here. And the limitation of fraud, there is no limitations. There is no limitation on fraud. So you can always file a suit to get your sister off because you weren't given valuable consideration and you never signed the quitclaim deed.
Yeah.
Okay, so you can go off of that and that will shut it down and remove her and stop all this nonsense. But I have to tell you that filing a lawsuit is going to take a couple of months.
Yeah.
Maybe 3 months.
Well, Lisa also gave another good suggestion there to go to the county and tell them that I didn't sign the deed and if that will invalidate it. Which I didn't. There's no, my signature is nowhere on that quitclaim deed that was done.
Mm-hmm.
It was just filed.
Yeah, the grantors have to sign it to give it over to the grantee. Mm-hmm. If your name is not on there as a grantor, then they should be able to do that, be able to fix it right then and there. Try that first, and then you'll know what steps you need to take after that.
Okay. We'll try it now. Okay, so you're saying if we call your number, that number you gave us, we can, you'll get back with us to make an appointment so we can have a consultation?
Yeah, you just gotta say you're a private client, your start date of being a private client, and then that will allow my assistant to know who exactly you are.
Oh boy,
did you
have to remember the start date, huh?
Just go look at your agreement copy and the date that you signed.
Yes. Okay. All right. Thank you, Avery.
You're welcome. All right. Going to MW Trust. You are unmuted. How are you? MW Trust, are you there? Just got to unmute your mic. Nope. Going once, going twice. You direct message me. You wanted me to call your name. Not there. All right. Going to Tanya. You are unmuted.
Hello.
Hello.
Hi. Can you hear me?
Mm-hmm.
Okay, great. So mine is a little unrelated to stuff we've been talking about, but I was going through to try and utilize the third-party debt collector letter.
Mm-hmm.
Can that be used for somebody who doesn't have a trust? Do I simply just remove the trust information from it?
Yes, it can.
Or is this okay?
Mm-hmm. Yes, it can. If you remove the trust, if it was an LLC that's being taxed, and use the LLC in replacement. If there's no other entity besides their name, just use their name.
Okay, so this, and I don't know, I don't think that it makes a difference and stuff, but this is it's for my husband, and it's a ticket that he got that he didn't pay, and it went to Alliance One for the creditor. So that's what I was going to try and use it for. I don't know if that makes a difference at all because it involves the DMV, and I don't know that makes a difference.
No, it doesn't. You can do it for that.
Okay. Okay, awesome.
Mhm.
That was all I need to know. Thank you.
You're welcome. I'm assuming that maybe he didn't show up at the courthouse, they got a judgment, and then they eventually sold that judgment to a third party, and now they're coming after him for the money.
Yeah, because he did a Mr. Ticket and they were supposed to have handled it somehow, and I guess they didn't. I don't know if they were the ones who didn't show up because they were supposed to be there, I think, on his behalf.
Yeah.
And then he ended up getting the ticket, and then it came in the mail saying that since he didn't show, he now owes the ticket, and it's a whole thing.
Right.
So
Yeah.
I'd rather just do the third party debt collector letter to just get rid of the debt entirely because it's now like,
Yeah,
paying
just be prepared to
$30.
do it 3 times, and that should take
Okay.
care of it.
All right. And I would do it like every 30 days, or is it like every 2 weeks?
Every
Optimally
30
similar.
days from the date you receive your green return receipt card.
Okay. 30 days from receipt. Okay. Got it. Thank you.
You're welcome. All right. Hey, Nancy, you're unmuted. Have any concerns in the chat there? Nothing there. All right, Isaiah, how about you?
Oh, I'm here. I'm sorry,
Okay.
Avery.
Okay.
Okay. I was just talking away and I didn't unmute it.
Okay.
Okay. Hi, everyone. I just wanted to reiterate that when everyone calls or anyone calls our 888 number, you have to leave an email address. We are not returning calls. We don't have time to call everybody. So our best line of communication right now is through emails. So please leave your email, please a very detailed reason why you're calling, so that we can slot you to the right consultant. And always check your spam or junk mail because it's coming from a do not reply email address. It seems to be going to the junk mail. So I've had people call maybe 3-4 times stating that they haven't heard anything. I have been sending emails. As soon as I get them, I'm doing them every single night. So it's not even taking me 72 hours, but they're likely going to your junk mail. So please check that first before calling back. If you've given me an email address that has a lock that does not accept do not reply emails, that might be an issue as well. But I've only had a couple kick back, and I try to reach out to those ones specifically with a text or a message so that they can leave me a better email or some type of communication. Okay, so please understand, we need an email, we need a reason why you're calling, and check your junk mail.
Sounds good. I think we'll do that loud and clear. Easy enough. Just sometimes we forget to check that spam box. I know a lot of times, even my emails coming directly from Duvall@consultant.com is going to people's spam box. For whatever reason, I don't know. Maybe we have to start adding these email addresses to their contact books so that the system will register it. But thank you. Thank you for saying that. And that should resolve a lot of issues when it comes to communication between one party to another. All right. So let's go to Flex. You are unmuted.
Avery, what's good?
Doing good. Doing good over here. How about you?
Doing well, bro. So I sent off my 8832B form not too long ago and got a response back from the IRS. And they were saying something to the effect of because it's a fiduciary relationship involved, that basically was nothing they could do. And I guess I had to go back, and they mentioned a form 56. And I was also looking at a form 2848. I was doing some research on that. But I'm trying to see, like, what is the best form to kind of use for this particular situation, and do I have to do this for each and every one of my my businesses as well?
Are you saying this is a response to your 8832 or 8822B?
Excuse me, 8822B, excuse me.
8822B, you're looking to update the trustee and the name and the address, right?
Correct.
Yeah, whatever they sent you is complete bogus. You can just go ahead and send a standard letter
Okay.
saying you want to correct the name of the trust that's on file, and please put the correct EIN number associated with that name. Put the date that you were given that EIN number, and then go ahead and list, this is the new name, this is the trustee, this is the address. Now make sure that it's coming from the trustee that you use.
The sole trustee.
The sole trustee that you used to get that EIN number. If that was yourself as a title nobility name, use that person.
No, but that's why I'm correcting it, because I used my government name for at first. My name's Legas.
Okay, so it has to be written as if it's coming from your ens legis, and you're telling them that you are no longer a part of this trust. The person to contact is such and such and such and such. Here's their address. And then you state the name of the trust is whatever you want that to be, whatever you gave it to them on file. Put the EIN number that correlates with that name, and then put the new address that correlates with that trust if there is a new address. Now, I'm talking principal, which is the country that you use. And then you got to also put the mailing address where you want them to respond back to. Just do a letter.
And just do a regular letter. Okay.
Just do a letter.
Cool. All right. Appreciate it, Avery.
Yeah, I've never received that for 8822B, but you know, nowadays we're getting all kind of stuff that just makes no sense.
Yeah, I got a consultation coming up with you next week, so I'll just show it to you when we talk. But yeah, it was kind of weird to me because they were basically telling me it was a fiduciary relationship that they couldn't get involved in. I'm like, well, that was the point of the trust anyway. But I don't know, it's just weird.
So yeah, bogus. We'll respond
Okay.
that way.
Cool. Thanks, bro.
No problem. All right. Yvette Calvin, you are unmuted.
Hello, everyone. Hey, Avery, how are you?
I'm good, thank you. How are you?
I'm well. I'm well. Avery, I wanted to know if you had received the paperwork for the agreement, because I sent it through an email, but I wasn't sure if that was the right email I was supposed to use, which was the consultant rep email when I sent that agreement through.
Yes, we did receive it.
Okay, great. Now, with that said, I was wondering if I could ask a question in regards to the agreement, if I'm allowed to speak on that, particularly the contractee agreement, specifically number.
We're going to have to keep questions to the agreement offline.
Sure.
Okay. I'm going to send you directly to our consultant. She'll answer the questions for you, Nancy.
Okay.
That same email that you sent it over to, she will reply to it there, and we'll answer the questions to any section of that agreement that you have, any section, no problem.
Okay, yeah, she did respond to that. As a matter of fact, I'm just still a little unclear about it because, yeah, just that small portion at the end, that little paragraph about the number 14. So she did respond, and I'm just a little bit unclear about.
Okay, I just sent you a direct message. Did you see it?
I'm sorry?
I just sent you a direct message here in the chat. Did you see it?
No, I didn't. Let me go to it. Where it says Duval consultation?
It's directly for you. So go ahead and respond your question to that, and I'll answer it for you.
Okay. All right. Okay.
Send it directly there.
Okay. And just a couple of more things. Say if I have a trust set up, which and I win lottery winnings, would they be able to still take out the taxes? Like say if I hit the $1 billion lottery, I'm just throwing
Nope.
it out.
They will not be able to set out the taxes unless you give them the authority to do that. So it's just like when you work a job and you're coming up on retirement, and let's say you got a 401k, you got different pension plans, 403b, IRA accounts. You're supposed to give the holder a W-9. And usually people fill the W-9 out with their personal name and their social security number. And they go ahead and make the payments or the checks out to that name. Out comes a 1099 at the end of the year for that money, and that's when that person is responsible for taxes. Well, if you want to avoid all that, this is where you have to use your trust enterprise that's under the laws of TEFRA. So you would say that you don't want them to pay you directly in your name. You want them to pay it directly to the name of the trust enterprise. You should already have a trust enterprise account opened and operating, so that way there's a place for that money to go. That's how you avoid the taxation.
Okay. All right. Yeah, because say if you did win $1 billion, you're only going to get like 300 and something million of that. That's a lot of money that's going to them.
Right.
So, okay. And then, okay, for the private mailbox, I know you said that to go to the DMV and give them that address. Now, do I have to do
Keep
anything?
it to one question per person. We have 3 other hands up. If we have enough time, I'll come right back to you.
Sure.
All right. Thank you, Yvette. Okay. All right. Let's go to Jim. How you doing, Jim?
You hear me?
Yes, I can hear you.
Good. Yeah, Avery, thank you so much. You've empowered me so much. This is a blast to do. I had a grand time with all this. Quick question. You talked about the fiduciary in New York that you might be changing or something happening there. Is that true?
One more time. You said fiduciary in New York?
Yeah, the fiduciary in New York. Yeah, to get our Panama, driver's license and get that handled.
We're working on getting another outlet for that. For different countries, but you still can utilize that same fiduciary. He's still in business. I'm just saying that there's no way for me to personally track how long it takes for them to return the document to you. Our track record right now, we're seeing that people are getting it anywhere from I've seen 6 months to 10 months. So that's a while. He does have a lot of orders. It's a lot. So you can do it, but it will be a while before you receive it. And so I'm looking to find others that can get that done much faster for you guys.
Yeah, that's what I'm debating on, whether to wait a little bit, because I just did my second round of injunctions, and I'm doing all this, so I'm gathering.
Well, you can have multiple foreign driver's licenses in the same title nobility name.
Right.
So if you got one from Panama, if you ordered it today and it came in 10 months, and let's say right around that 10-month time, I accumulated another jurisdiction, like let's say South Wales, Australia. Well, you can go ahead and order a South Wales, Australia foreign driver's license in the same name. Have multiple driver's license.
Okay.
Yeah.
So that's what I'll do. I get the Panama license first, and then we'll deal with it later. All right.
Yeah.
That's
so
what
you guys got to send me the your direct interest for it so I can forward the application to you, because it's no longer on Patreon as a direct thing.
What, the PATA?
PATA, you already know how you can get that online, but the actual application for the fiduciary in New York, send me your interest in that and I'll give you the application.
Thank you. Be well.
All right. Cool. Jesus, how you doing?
Hey, what's up, Avery?
What's up, man?
Happy Saturday.
Oh yes. Got a lot of work to do as soon as we get off this call, but it's still.
I hear you. I real fast. Thoughts on pledging the ABC through the Federal Reserve Board to redeem the credits from the Treasury.
Where have you heard this from?
Been doing a little studying.
Yeah.
Yeah.
Well, we know to do a pledge, that's synonymous with giving up some form of a promissory note. So there is a way to do that. And it's not the way that most of these forums out there are talking about. You are going to have to you're going to have to get a permit as an issuer or a reseller of bonds, notes, contracts, and different terms like that. But you got to get it a permit or license through your local banking authority. Now, you can't run away from the fee to get this permit or license, but once you get it, you can avoid all of the scrutiny that other corporations are required to get with the SEC. So there aren't going to be any type of registered securities that you have to do with the SEC. You avoid that with Rule 144A, but it's going to first start with your declaration of trust being filed in the county the way it's supposed to. And then you want to have an LLC or a corporation or what do you call it, an unincorporated association to operate as its trustee. Go and apply for this specific permit. Once you have it, you can now offer for sale certain securities. You can look at Rule 609.8 in Florida where it talks about that, but it's codified in every state, no matter where you are. These are rules that the trust has to do. Now, let's say you have something as small as a insurance, life insurance. They're going to give you a contract that you have to sign. The insurer will sign the contract for, I don't know, $5 million death benefit. You can use that as collateral to sell your bond. And then comes back the money.
I like the sound of this. Are you trying to like put in a nutshell, like an initial public offering? Okay.
Can't speak too much on it though.
I know this was going to be a little spicy question. All right, Avery, thank you. And I want to be part of that special webinar.
Okay.
Because I got to do my taxes in February and I put in my work. I help everybody in Telegram. Don't forget me when you're on the Hollywood Walk of Fame, okay?
You'll be right there.
All right, Avery, take care, brother. I appreciate you.
You too. Thank you. All right, so it wouldn't let you unmute, Mr. Liaison. Try again.
Yeah, I'm good now.
Okay.
All right, so I'm gonna read some questions that people haven't gotten, excuse me, a chance to speak. We have one from Yohanatan Hebrew Prince. He says, to piggyback off that question in regards to the couple's estate, does each spouse do a trust where they live or where are they born?
Well, it's going to be a foreign express trust. So it has to be established in that foreign country first. The mailing address can be wherever you want. Most likely it will be in the proximity of where you live. So you can pick up the mail there. When it comes to your birth certificate authentications, that has to be done where you were born. But, recording this information can be done anywhere you want. Okay, so birth certificate has to be completed in the state where you were born. Once that is done, you're going to record that information in the county that's most effective and close to you. Simple as that. What else we got?
There's a few questions people are asking, but they've already asked, but I'm just going to go through new questions. Can you share, or it's Gita, can you share what we file our DBAs under the at the county? And does it matter if it's titled affidavit or declaration? Newbie here.
It does matter what it's titled, because if you have the wrong title, the clerk is going to be confused as to where to record it. So go to your county and search search the name of your county, followed by recorder clerk document search. And just go and take a look, see how they structure their sections there. If you find they have a section called affidavit, boom, there you go. You're going to title your document affidavit of fictitious name. If they call it something else, call it that, followed by the words fictitious name. So that way they can slide into the door easily. All right. Just go back and watch the video on affidavit of domicile and miscellaneous file, and you'll see the examples of how I searched that within Seminole County, Florida. All right. Any other questions we got?
Yeah, so Lisa Pizzella, she had her hand up earlier and then lowered it and then asked a question in the chat, but I don't see any direct questions that she's asking. Lisa, if you have a mic, can you go ahead and ask a question that you had? Lisa Pizzella.
Yeah, hi. I was trying to click it. No, I was just saying that I've been trying to get an appointment. That's all. And the assistant was saying, what do I want to talk about? But I have a few different questions. So they're all relating to the freshman class, and just going through all the data I've written down in my notebook that I have several questions. I got to one of them today, but I just wanted to make an appointment for a consultation. I called immediately after our webinar last Saturday and still haven't been able to get an appointment. That's all.
Okay, I will look at yours specifically because of the time frame. Okay, and we'll get you squared away with a link. Thanks for that comment. Thank you. All right. Anything else in there, Isaiah?
Yeah, there's questions, but they're from people who already have asked a question. Do you want me to read those or?
We'll come back to it. I got one person with their hand up that I haven't gotten to yet.
Gotcha.
All right. Shubi Yahoo, in Yahuwah we trust. You are unmuted.
Shalom, Avery.
What's going on?
I hope my background, I'm driving, so I hope my background's not too bad for you. You still hear me. The question I have is, when you file for your 8832, do you know how long it takes? Because for me, I filed mine back in early part of August, and I haven't heard anything yet.
Well, that's normal. Welcome to the club.
Okay, that's what I was asking. Is that, a long process? Or?
Yeah. Usually after 3 months, we send it again.
Okay, so I'm going on the 3rd month now.
Yeah.
We'll see.
Yeah, send it again. And guys, it's the same rule applies when it comes to that correspondence letter you send out after you've been given your 98 number. If it's been 3 months, send the letter again. If it's been 3 months for your 8822B, trying to update that information, send it again. You have to flood them with this information. You gotta let them know you're not going away. Give me an answer. Same thing with the passport. Give me my passport according to the Articles of Confederation. So you got to enforce what you want. When it comes to this, they're not just going to give it to you. We got to fight for it. Thank you. Good question. And I've been meaning to say that, remind people of how long this thing takes. People ask, how long does it take to complete this process? It used to be 2 months back in the day. Now we have more people coming into the Republic and filing their express trust. They see that a confederation is coming back together. When you guys are doing all of this, you're creating a confederation without you knowing it. So they are going to slow the process down. So, all right. I'm going to go to Yvette. I'm going to open you back up. I didn't mean to cut you off. If you have that last question, go ahead and ask it.
Sure, Avery, thank you for coming back. I just wanted to comment on the private mailbox I know you said that go to the DMV and use that address from the private mailbox. And I was wondering, do I need to do anything with the post office or just leave things the way they are at the post office with my address?
You don't, but you could. You can go to the post office online and use that simple tool that they have, the change of address. I believe it costs $1. So everything that used to come to your home address will now go to the iPostal One. And from now on, you'll start picking up your mail from there.
Okay, okay. The reason why I asked that is because if I have everything that's coming to my address now, it'll just be rerouted to that private mailbox. I don't have to notify them of that change of address.
It will be rerouted automatically. That's the
Okay.
point, updating the postal service.
Okay.
But what I did, I didn't want anything to be late or delayed. So I just went ahead and updated it with everybody on the forefront.
Okay.
Banks, everybody that I normally deal with. I just do a simple update. You could do that online.
Okay.
Mhm.
All right. I think that was it. Yeah.
All right. Thank you.
Mhm.
All right. Let's go to MW Trust. You are on mute. How you doing?
Hey, brother, can I be heard?
I hear you. Mhm.
Okay, cool, man. You starting to worry me for a sec. I thought I wasn't gonna be able to get on. But hey, man, I definitely appreciate what you're doing. The brother that had the spicy question, man, hey, man, that little exchange answered the question I've been having for years. So, man, it just definitely much appreciation for what you do. But so I got a full, I guess the full course, and I was going through everything. I think you've already seen what I was asking, but as far as getting the state EIN, that's the concern because from what I saw in the video, it makes it seem like it says something about a decedent. Like I guess it's tailored towards dead people. So my thing is if I'm trying to open up an EIN, if I'm not dead, I just want to make sure like what law or rule that supports me being able to do this.
Look up the laws of life estate. Okay. Let's say you have someone who is on their deathbed. Let's say it's me, right? I've been diagnosed with something that I can't cure, and they tell me I have 7 years. Well, I can start prepping my estate to be turned over to the next generation. As of right now, I got 7 years to go, and I can go and file as my own executor to go and get my own estate number. And I am not considered deceased yet. You can do that. If you couldn't do it, the IRS system would not allow you to enter your name, your own social to get an estate number and to list yourself as an executor. They will spit back certain information if you can't do something. So yes, you can do it. It's considered your life estate. You will control that during the life of the settlor. You are the settlor. You are alive. And once you pass, all that information, all that stuff that you benefited from when you were alive goes to the beneficiary. And now the trust becomes an immortal trust. That's how that works.
Gotcha. Would it be too much to like send a notice in to them before I do this, just so I can have some kind of paper trail to cover me if they try to come back at me? Or
the IRS?
Right.
No, you just apply for your estate number and then do the 8832 process, putting that estate number under the trust, and you'll get an approved form back. That's the correspondence that you're looking for.
Got you. And as far as the 8832, is there a specific law or rule that allows the domestics to be reclassified to foreign entities?
Yeah, it's in the Internal Revenue Manual.
Okay. would you know that off the top, or
all you have to do is search IRS publication, entity reclassification, and it's going to give you everything you need. Or you just pull
Gotcha.
up Form 8832. There should be an attached instructions to it, usually the last page. And that will give you the laws behind what you're doing.
I got you. Got you.
Every day. TransUnion, they're over in Australia, but it says that their main headquarters is in California. So that means they have a domestic entity here and they want to avoid taxation within the United States. So they have Australia to be their 9-8. They have done an 8832 process off of their California office, their California EIN incorporation, and filed that under their Australian 9-8 number. Now they avoid taxes. You are doing the same thing.
It makes total sense. I appreciate it. My last question was about the consideration. Like with doing this promissory note, like what's the consideration that the trust is giving the in legas?
The consideration is the monetary value behind the birth certificate.
So is it sort of like is a line of credit or something, or?
It's not a line of credit. However, it is the ultimate certificate of title that the trust can hold in order to exempt its user from taxation. Right now, that certificate of title is under what's called the corporation sole, which is the Vatican, the Roman Catholic Church, the vicar. That's where taxes are being collected and turned over to them. Well, you're going to need to turn it over to someone else, and only you can do it. That's what the Sestu KV Act is talking about. You're the only one that can claim your estate and turn it over to whomever you want. And it needs to be a natural person, which is the express trust. That will stop taxation because you have a valid contract, which is backed by the collateral of the birth certificate, and the trust is holding that title. So you have to have that promissory note in place.
Okay, that just spawns from, because when I hear a promissory note, it always seems like it's a lender borrower type of situation. So like, what is the lender giving the borrower, which will be the in legas? So
in your promissory note, the trust is lending $9 billion, right? Now your birth certificate, you have about 10 of those in existence, maybe even more, right? It is unknown, according to the omnibus, how much is in those actual certificates in this omnibus. An omnibus is a pool of investments that comes together between certain different people that are born within a certain year. So if I was born in 87, there should be about 1 million people in that omnibus that's backing up these certificates of title. Okay. Now, when you give that over to your trust, or actually you first do the authentication process, guess what happens when the Department of State gives you a certificate? They write on there that this certificate of title is now under full faith and credit. Now it's in limbo, waiting for it to go in the hands of a rightful owner. Rightful owner has to be the trust. That's what the non-UCC is all about, to actually have that property listed as collateral with the trust, the secure party. You list the trust as a secure party in box number 3. When you look up the UCC terms, secure party is a lender. The debtor is a borrower. So what exactly is the trust lending the borrower? Freedom.
Right. Man, much appreciation, brother. Thanks for your time.
Very, very welcome. Very well. Well, we got one last question because we're going through them. We've answered everybody, but AJ, got another question for us? Go ahead. You are unmuted. Can you hear me? I think your mic is still muted. Nope.
How about now? Anything?
There it is. Good.
Okay. Sorry about that. You're not hearing any reverb from the speakers, are you?
No.
Okay. All right. So my next question is, let's say that what the suggestion that was given to me, that I go down and see if we can invalidate what was done, that old quitclaim deed. And now that means it reverts back to me and my mom being on title. Would I need to do a quitclaim deed to put it into the trust?
Yes. If they act retroactively without a court order, then yes, you would have the position to take it directly into your trust, you and your mom.
Would we need a quitclaim deed for that?
It's the same one that you have. You just remove your sister's name off of it as grantor and put you and your mom's name as grantor.
Okay. Thank you.
Mm-hmm. You're welcome. All right, that was everything. We are going to continue reading this IRS manual next Saturday. What day is next Saturday? Is that close to Thanksgiving? We'll find out. I don't know. But very good questions today. Very great participation from everybody. Hope you gained a lot of information from it. This was recorded, so we will upload it. Please go back and watch these videos. Go through it. Go through as many of these videos as you can. We have enough in there going all the way back to December of 2021. We are successfully coming to our first, well, we've done a year. This is a year existing with Patreon and showing this information privately. It's working well, so very happy about that. I'm going to let my assistant close out here. You are muted before I let you go.
Hey guys, Avery, this is really towards you. Actually, I just want to make it clear, you do have your calendar open on Thursday. I want to make sure that you close that. It is actually Thanksgiving Thursday and you cannot work Thursday.
Okay.
So I just want to let you know that you guys, Avery tries to put so much into this. He does put so much into this day and night. We're up late nights doing this. And so we do appreciate your patience with us and getting back to you. We appreciate your patience and understand that Avery is one person. And so I just wanted to make that point. Thanksgiving week. So we're very thankful for Avery and his knowledge and the time that he spent to teach us all. So again, I just do appreciate your patience and understanding he is one person. Okay. All right. You guys have a good one.
Thank you so much, Nancy, for that. We are busy, but it's good work. It's the good work. So we got to keep it going. So thank you guys for everything and look forward to the version 2 of the courses. Try to get you guys to speed track this thing and get over the hurdles that the counties like to push on us when we make it. So some of you guys have already made it, and then they're taking that amount of people that have done it and said, oh, we need to flip the script on everybody. And the counties, they do talk with each other. Very, very funny, but we will prevail. So thank you guys again. That's going to be it for today's Q&A, and I'll see you guys next or after. In 2 weeks. See you guys in 2 weeks. Take it easy.